can sometimes indicate my understanding of the issues or whether I am accepting arguments from counsel. It is not meant to put down parties or be directed at a party. I will note that I do have a practice when I am in deep thought on an issue. I do sometimes put my face in my hands. It is not an expression of disgust or rejection outright of a party's motion in front of me. Again, I aspire not to do those things, but human nature at times can do that. I am always super cognizant of that when I am in front of members. Again, those facial expressions in eye rolling, I don't do as a matter of practice, and certainly I do not do unbalanced to either party. Regarding the unfairness of holding both parties to a standard, I would say that I have no doubt that I've been balanced throughout litigation in this case. The defenses in both parties have litigated a significant amount of motions. The unique situation that we're in, based on the challenging issues in this case, COVID-19 in those issues, and now adding on the capital issue here has been challenging on all parties. I've issued 6 court orders, and I've allowed counsel, I believe, 6 Article 39As to litigate motions in this case. Regarding discovery issues in particular, the court notes that I have granted continuances, although it's not what the defense asked for. They asked for dismissal. I have provided remedies, including the latest remedy of monitoring discovery emails from 18 November until today, in order to rectify those issues, any issues that the court felt needed remedying for the defense side. Again, so in order to determine whether the comments or my actions require recusal, the court must use the objective person standard and take into account all the circumstances and determine whether, in light of those circumstances, a reasonable person would be questioning the impartiality of the judge. The court has considered all the circumstances, and I'm making a determination that a reasonable person would not question my impartiality throughout this trial. At this point, I have issued a significant amount of rulings. I have not counted those, but I suspect they are approaching 40 written rulings. Those written rulings have been certainly balanced and taken in both parties' arguments and the evidence allowed to be submitted at those Article 39A sessions. I have contemplated every argument sent before me from counsel. I have considered the evidence offered in support of those motions. I've attempted to apply the law to those facts and the arguments in issuing my ruling. I am certainly not advocating for either party in this case. My job under RCM 801 is to continue trial without further delay, and unless there is a motion for continuance or that I need to consider, my motivation is to conduct this trial fairly and conduct this trial timely, as I have been instructed to under RCM 801. Regarding the COVID vaccine issue, the email, the intent of the email was just good manners. My intent was to say thank you to the command that had put my name on the list. It was certainly no indication of my affinity for the Legal Service Command. It has been my practice in 20 years of commissioned service, when somebody does something nice to you, you should say thank you. But as a military judge for now 5 years, that is all the intent was. Certainly will not bleed into how I conduct this trial, how I rule on the issues, and how I feel about counsel. So, based on the objective standard, the court finds that a reasonable person would not question my impartiality, and thus your motion is denied, counsel.
Are you waiting on me, sir?
What's next, counsel?
We're actually asked for a brief recess, Your Honor. I need to be able to consult with Commander Ely about a decision that he has to make in light of the court's ruling, sir.
Sure. How much time do you need?
20 minutes, sir.
Take as much time as you need, but I'll check in 20 minutes.
Yes, sir. Thank you.
Very well, court's in recess. All right. Carry on. 13, all parties present when the court last recessed are again present. Counsel, defense counsel, have you had enough time to speak with your client?
Yes, sir. Thank you.
Okay. Are we ready to proceed?
Yes, sir.
Okay. So, based on our discussion this morning, the first thing we'll discuss from submitted motions is the motion to dismiss charge 5. And that is entered into the record as Appellate Exhibit 207. The government's response is entered into the record as Appellate Exhibit 208. The court's ruling is reserved for Appellate Exhibit 209. Lieutenant Phipps, this is your motion, correct?
It is, sir. Yes.
Okay. Do you have any additional evidence to offer in support of this motion?
No, Your Honor. I mean, this is purely a question of law.
Okay.
As far as any burden exists, the burden's on the government to just plead a specification that properly states an offence. I'm happy to address the government's response and argue first, if you like, sir.
I would like you to argue first.
The government's first argument's response appears to be that this motion is somehow untimely, even though this is a motion that may be raised in any stage of proceedings, even including after findings. Do you need me to address the timeliness?
No, I don't need you to address the authority. I'm going to issue a ruling on it. I'm just curious as to why I'm getting it on December 24th. After, the charge. Their point is this charge hasn't changed since it appeared on the charge sheet. So, were you holding this motion, or did it just kind of, as you were prepping for trial, the issue appeared?
I might have waited until after the jury until the jury went to deliberate if I was holding it, Your Honor. So, I mean, we filed this in advance of trial, so it was not to surprise the court, not to surprise trial counsel. We're not playing games here. I understand that the government's response to our motion seems to suggest that, hey, this is indicative of some sort of gamesmanship, and it's one of two responses they've recently filed which seem to call into question my integrity and Lieutenant Brett's integrity, which...
So, all I'm looking for, counsel, is, as I looked at it more closely, it appeared to me I fully understand you can look at a charge 40 times, and the 40th time something different appears to you. Is that what happened here?
Yes, sir. That's what happens in every case. I look at a charge, and you're always reviewing the charges closer to trial.
Sure. Okay.
So I filed this as soon as I could.
Okay. That's all I needed on that, counsel.
Understood, sir. So getting into the actual merits of this argument, sir, and for the most part I'm standing on our papers here. The law is pretty clear. The specification alone has to allege, either explicitly or by necessary implication, each and every element of the offence. And the sole specification of Charge 5 does not. The government seems to rest its argument mostly on U.S. v. Atty, and they claim that it pronounces this rule, which, number one, it didn't. So U.S. v. Atty was a 1992 case, I think, which dealt with an obstruction of justice charge. That's where the similarity between that case and this case ends. Atty wasn't looking at whether or not that specification stated an offense. Atty was looking at whether or not the evidence was sufficient to support a conviction in that case. All the trial counsel does is restate essentially part of one of the elements, and then they try and convince the court that, well, element 2 actually isn't a real element. It certainly is. They've added a reference to the number of times certain appears in the punitive articles of the UCMJ under elements of offenses. It appears an awful lot. It appears in almost... I went through them the other night. I stopped tallying up how many times the word certain appears. Each time the word certain appears in describing a person, it's because the specification is required to allege who that certain person was. The trial counsel, in their response, they've hung their hat on 112 alpha and some case law that says, well, yes, you're required to possess a certain amount of an illicit drug in order to be guilty of that crime, so that must be pled, and that it's sufficient to plead in marijuana cases, for example, that somebody possessed some marijuana. They're still specifying what that something is, the marijuana, and that's the whole point. Where certain applies to a something, which in this case is a person, that has to be alleged, and it hasn't been alleged in this case. And the government's response makes no attempt to clarify, and it doesn't matter if it did clarify, because this court cannot rely upon the evidence or arguments of counsel. This court can only look at the language in the specification, and what can I infer by reading Charge 5 and its sole specification.
Okay, and again, your motion zoned in on the second element, correct? And that second element is that the accused did so in the case of a certain person against whom the accused had reason to believe there were. So it's the a certain person clause, right? I read your motion correctly. That's what you're attacking.
Precisely, with that entire element, Your Honor. A certain person, and then against whom that person had reason to believe there would be charged with criminal proceedings pending. We quoted the model specification as well, which lists in the case of, and then fill in the blank explicitly by. That's in every model specification going back from the current MCM, 2016 MCM, to the 2012 MCM. Granted, it's under 131B in the current MCM, not 134. But that language exists.
So the one thing I 100% agree with the government on, right, is model specifications are just that, right? They are used as an example. They are not a requirement.
But think about where that came from, Your Honor. That principle. It came from, I don't have the case off the top of my head. I'll be happy to supplement my brief. I think it's probably cited in here. But analysis of a failure to plead the terminal element in a 134 case. And the government's response in trying to defend why they stated a specification correctly was, well, the terminal element doesn't appear in the model specification. And because we followed the model specification to a T, therefore we obviously stated an offense.
You're talking about phosphor?
Phosphor, yes, sure.
Yeah. Okay.
No, I mean, that's an example of the model specification not listing all the required elements. What more recent case law tells us, it's even in turn, and I'll give you the pin side as well, that a government agent or a government lawyer drafting and swearing specifications fails to follow precisely the language in the model specification at his or her own peril. That's what the current dicta from the court is. So just saying, hey, these are just guidelines. Sure, tracking. We know that because the government wasn't able to successfully defend a facially and constitutionally deficient specification by just relying on the model specs.
Okay, so I'm tracking that. I really think this turns on the language of RCM 307, right? So RCM 307C3, right, when we're talking about specifications, is a plain, concise, and definitive statement of the essential facts constituting the offense charged. A specification is sufficient if it alleges every element of the charged offense expressly or by necessary implication. So really, my decision on this motion is whether it certainly doesn't say expressly, right? So now I need to make a decision on implication. So can you talk to me about that, please?
Yes, sir. And take a look at Turner. Take a look at 49 MJ 401. Turner was a motion to dismiss a charge of failure to state defense only raised after findings. So there was a different standard of review there. And it was a real close call in Turner. There was a dissent in Turner. The close call was they found that this specification, that all it did was it admitted the word wrongfully in an attempted murder spec. The government charged attempted murder, and they didn't put wrongfully killed. So the court took a look at this, and because it was after findings, they concluded they could at least infer by necessary implication the words wrongfully from some of the evidence in that case and some of the defenses the defense had put on. They concluded, obviously, the defense there knew that they were charged with an attempted wrongful killing of this particular individual in this case. But what that opinion also shows us is that if this is raised before findings at any time, you can't look at the evidence or what counsel did to prepare for trial. All you can look at is the language of the specification itself. And look at the dissent in Turner. That's not necessarily implied in Turner. The word wrongfully was not necessarily implied just by the specification. And so here, read the specification, that Commander John A. Ely, U.S. Coast Guard, on active duty, did at or near Groton, Connecticut, on or about 23 December 2015, wrongfully endeavor to impede an investigation by providing a false statement to members of the Groton Town Police Department, to wit, Aidan Ely was never alone with any, or worse to that effect, which conduct was of a nature to bring discredit upon the armed forces. I see no clause, no sentence in there that necessarily implies which investigation Commander Ely is alleged to have impeded, in the case of whom. We can't infer that from this specification, sir. Just to illustrate, as I illustrated in our motion, it was just an illustration. This isn't us saying, hey, these are the only two options, but we came up with two potential hypotheses. Maybe they're saying it was an investigation into Commander Ely and he obstructed. Maybe it was an investigation into somebody obstructed. Maybe it was something entirely different. We don't know. The point is for this specification to survive, to state an offense, and to give Commander Ely notice of that which he has defended himself of, it needs to allege the second element, and this does not. And if we can't read that second element into that specification, looking at the specification and the language of that specification alone, then there is no necessary implication. And the government's response fails to address any of that. They ask this court to rely on a rule that isn't a rule from a case that isn't binding on this particular issue about what may or may not be obstruction of justice.
Okay, I was trying to pull up Turner here, Counsel. Can you give me that site again?
49 MJ 401, sir.
Yeah, I don't think that's correct, Counsel.
Sorry, 79 MJ 401. That is
79?
Dyslexic. I apologize.
Okay.
It's in my brief, Your Honor.
Yep. Okay.
So the question becomes, Your Honor, based upon this specification alone, is how is the court supposed to instruct the members on this charge? In instructions, we submitted proposed jury instructions. I took a look at them again. The court's going to have to fill in these blanks with a name, and we don't have a name from this specification. Going down in the additional instructions on 134 obstructing justice, it's in our motion. You're going to have to instruct the members of the accused does not have to note that the charge has been brought or proceedings have begun, but the government must prove beyond a reasonable doubt that the accused had reason to believe there were or would be criminal proceedings against, and insert name here, a certain person.
So, I'm tracking you raised this before trial and looking at the specification. But as far as instructions, which are the judge is required to tailor those instructions to the facts as they come out at trial. So isn't that a different way of looking at it? So if facts come out at trial, couldn't I apply those facts to the instructions?
The answer is no, sir. You may not. Because there's no notice. The government doesn't get to charge a specification, admit an offense, and then hope that somebody fills that gap that they committed, and give you the option after evidence of, well, maybe I'll insert John, or maybe I'll insert Andrew, or maybe I'll insert Kevin, right? Stick a name in there. Take your pick. That's not how this works. The specification has to expressly, by necessary implication, state each and every element of the offense, and that includes a name in this case. And you have to be able to, before we even receive evidence, have an idea as to what elements the government has to prove. That has to be established before opening statements.
So there is a name in this specification, right? And the name is Aiden Neely.
That's in a different element, Your Honor. That's under the accused. That goes to element 1. What did the accused do? He said something about Aiden Neely. That goes to element 1, not element 2.
Well, he provided a statement to the Groton Town Police.
It's element 1.
Okay.
There's nowhere in the specification we can find element 2. I mean, they've alleged an act. All right, we'll break this down. In the Commander John A. the U.S. Coast Guard active duty, did New Groton on or about 23 December 2015. Okay, we got the jurisdictional data and all that in there. He wrongfully endeavored to impede an investigation. All right, so that's element 3. What? By providing false statements to the members of the Groton Town Police Department to wit, Aiden was never alone with any worse than effects. That's element 1. Which conduct was of nature to bring discredit upon the armed forces. That's element 4. Where's element 2? It's not there. And we know it's not there because the model specification that they should disregard at their own peril says there's another word you're supposed to put in here. In the case of underscore to wit, it's not there. Okay? We have to engage in some real mental gymnastics to try and save this specification, which is not how we're supposed to analyze that when this is raised before findings. The question is, look at the spec. Is everything alleged? No, it's not. Then it's dismissed. There's no other alternative there, sir. It's constitutionally deficient.
Okay, I understand your argument, Counsel.
Yes, sir.
Trial Counsel. My first question, Trial Counsel, is why didn't you follow the model specification?
Your Honor, I don't have an answer to that question.
Okay, so based on the language of Turner, right, you are now arguing from a position of peril. So talk to me why, I believe your motion, your best argument is that this is by necessary implication.
I think that's an argument. I think the second argument, Your Honor, is if the defense version of the rule is correct, which also is not supported by, they said the government didn't cite an actual rule. There's no rule that you have to name the certain person in a specification, and that makes sense from a logical standpoint, because if that's the law, then someone cannot obstruct an investigation unless they're privy to the internal workings of a police investigation and actually know the specific target of an investigation. So the standard, the rule, the element is that you have to have intent to obstruct an investigation that you're either aware of or that is reasonably foreseeable. Now, as long as we can prove that beyond a reasonable doubt, we prove that element. We don't have to prove that the defendant knew the precise target of any hypothetical investigation. As the case also says, there doesn't even actually have to be a formal investigation. There don't have to be charges. There doesn't have to be a court case. He just has to have the intent to obstruct a hypothetical investigation, and we have to give him fair notice, not perfect notice, of the charge. As the court pointed out, there is a name in the specification. The name is Aiden Ely. The specification informs the accused of exactly where he is alleged to obstruct an investigation, to whom he did an act to obstruct, what that act was, and what it was in relation to. All of those facts that, contrary to the offense's assertion that they're outside the scope of the specification, they're in the specification themselves. Taken together, read together, the specification as written does allege every element of the offense. Yes, it does not quote, fill in the blank of the certain person, but there's no requirement that it does. The defense did not cite any case, any rule that says you have to name the certain person. They're attempting to turn modest specifications into a magic formula that if you don't cite every single word, regardless of what the purpose of the word is, into a rule that doesn't exist. The comparison to Fosler is completely irrelevant. Fosler neglected to allege the terminal element of 134. Three completely different theories of liability. The Turner case neglected to allege the intent, wrongfulness of the killing. Here, the only thing that is not in the specification itself is something that's not an element of the crime, i.e. the precise target of a hypothetical police investigation. The element is that the defendant had the intent to obstruct an investigation that he knew about or reasonably should have known about.
Okay. Thank you, counsel.
To be clear, Your Honor, the element is that the accused did so, element 2, the accused did so in the case of a certain person against whom the accused had reason to believe there were or would be criminal proceedings pending. That's the element. The government is asking this court to ignore an element. Save our specification, ignore element 2, we're fine. We cited rules, we cited law. Fosler and Turner, that is the law. That is the rule. A specification must, expressly or by necessary implication, allege each and every element of the offence. That's the law that applies to this case. They failed to do so, and their only argument is, it's not an element, Your Honor, it doesn't matter, we've alleged something. This is a specific intent crime. Of course they're required to allege the certain person against whom the accused had reason to believe there would be an investigation. If that wasn't an element, it wouldn't be in the manual. The President wouldn't have put this model spec in an executive order. It's there, it's missing. This specification has to be dismissed, Your Honor. I can just briefly, Your Honor, if I could. I mean, saying the word Aiden, again, that covers element 1, not element 2. That means nothing towards element 2. There are 4 different factual scenarios or potential investigative scenarios at issue in this interview. Maybe an assault investigation between Commander Ely and his son Aiden. Maybe a sex assault investigation against Aiden for allegations involving Emmy. Maybe an investigation of Commander Ely for failing to report that alleged sexual abuse. Or 4, maybe some belief about, there was some reference in that particular interview about Commander Ely's mother-in-law having a fight with the Dowdell grandparents. Right? It could be an investigation into any one of those things. We don't know. So because the specification doesn't include that element, how can the defense be possibly prepared to defend against it? And it's not one of those things. The court suggests we get to wait until trial, let's see what the evidence says and plug and play afterwards. No. The Constitution demands that Commander Ely be on notice now, and he is not. Therefore, it fails to state an offense.
Okay, counsel. Give me a moment here, please. Okay, the court's going to issue the following ruling from the bench, and I will follow this up with a written ruling. Pursuant to Rules of Court Martial RCM 907B2E, the defense filed a motion to dismiss Charge 5, claiming the sole specification failed to state an offense. The government opposed the motion. The issue presented is, does the sole specification of Charge 5 state an offense? Charge 5 on the charge sheet states that in that Commander John A. Ely, U.S. Coast Guard on active duty, did at or near Groton, Connecticut, on or about December 23, 2015, wrongfully endeavor to impede an investigation by providing a false statement to members of the Groton Town Police Department, to wit, quote, Aiden Ely was never alone with M.E., end quote, or words to that effect, which conduct was of nature to bring discredit upon the armed forces. The elements of obstruction of justice pursuant to Article 134 is the first element is that the accused wrongfully did a certain act. The second element is that the accused did so in the case of a certain person against whom the accused had reason to believe there were or would be criminal proceedings pending. The third element is that the act was done with intent to influence, impede, or otherwise obstruct the due administration of justice. And the fourth element is that under the circumstances, the conduct of the accused was to the prejudice of good order and discipline in the armed forces, or was the nature to bring discredit upon the armed forces. The military's notice pleading jurisdiction. I cite United States v. Cell, 3 CMA 202-206 from 1953. The charge and specifications will be found sufficient if they first contain the elements of the offense charge and fairly inform a defendant of the charge against which he must defend, and second, enable him to plead an acquittal on conviction and bar future prosecution for the same offense. I cite Handling v. United States, 418 U.S. 87, 1974. Also United States v. Resendez-Ponce, 549 U.S. 102 from 2007. United States v. Sutton, 68 MJ 455 from the Court of Appeals for the Armed Forces, 2010. And United States v. Crafter, 64 MJ 209, a CAF case from 2006. The rules governing court-martial procedure encompass the notice requirement. A specification is sufficient if it alleges every element of the charge offense expressly or by necessary implication, citing RCM 307C3 in United States v. Fosslin. The requirement to allege every element expressly or by necessary implication ensures that a defendant understands what he must defend against. Indeed, no principle of procedure due process is more clearly established than notice of the specific charge and a chance to be heard in a trial of the issues raised by that charge. Citing Cole v. Arkansas, 333 U.S. 196, and again Miller, 67 MJ at 388. The court offers the following analysis. The sole specification of Charge 5 states an offense by necessary implication. The defense motion focuses on the second element, arguing that the government fails to expressly or by necessary implication allege what person the accused had reason to believe there would be criminal proceedings pending. However, the specification identifies the agency conducting the investigation to which the accused made the investigation to, and the subject, Aiden Ely, about whom the accused made the statement. This information would serve to fairly inform the accused by necessary implication of the nature of the charge and enable the accused to plead to the charge and protect himself against double jeopardy. As such, the court finds that the sole specification of Charge 5 states an offense. The defense motion to dismiss is denied, consistent with the above conclusions of law. And again, counsel, I would expect at some point this afternoon or this evening, I will submit to you the written ruling on that. Okay. Is it time for a break, counsel, or do you want to move forward to the next motion?
Yeah, the government's prepared to proceed.
Okay. And I have the motion to abate as the next motion to discuss.
Sounds good to me, sir.
So push forward?
Yeah.
Okay.
What's okay with that?
Yeah, absolutely. All right. Again, the defense filed the motion to abate. and that is entered into the record as Appellate Exhibit 210. The government's response is Appellate Exhibit 211. The court's ruling will be reserved for Appellate Exhibit 212. Okay. Defense?
We have additional evidence to offer on this motion as well, Your Honor.
Okay.
Off the top of my head, I think the next enclosure.
Yeah, and I don't want to get, I don't think from the recusal motion, did we get those emails in as the next attachment?
You know, you asked me if I could provide a copy of the court reporter?
No, I forget how we labeled them. I think you asked for the next appellate exhibit, but would you want that just attached to your enclosures?
I think we labeled it Appellate Exhibit 238, Your Honor.
Okay. Okay. Moving on.
I think this is most likely Kilo Victor, Your Honor. We'll get the court reporter.
Okay. Just, yep.
I'll provide a copy to the judge right now. Copy to trial counsel.
Sure.
Enclosure KV, Your Honor, consists of this entire document here. I don't have the exact number of pages off the top of my head, but it's a 5-page letter from Ms. Sina Wong accompanied by 30 enclosures to that letter to evidence the steps that she and the defense counsel have taken to ensure that she can somehow get funded. This is a simple motion and a simple remedy that's still urgently required. And the reason we need to add this enclosure to this particular motion is because over the course of the last several months, the trial counsel continues to email the court with misinformation about Ms. Wong's current funding status. They continue to cast aspersions on the defense team, alleging ultimately that this is some kind of tactic that imbues a benefit to us by not having an expert in time for trial, or that we've failed to exercise our due diligence in attempting to help fund this particular expert, that we're just being incompetent or unethical in our duties. None of which are the case, Your Honor. This is simple. This court found that Ms. Wong was necessary. Her expert assistance was necessary for a fair trial in this case, and signed an order ordering that she be provided to the defense. The government then has an obligation to fund her. In the Coast Guard, that funding apparently cannot happen until Ms. Wong has a contract in hand. And in the Coast Guard, under the rules that the government, big government, put in place, that contract cannot exist until the expert consultant has gone through SAM and DUNS and CAGE. There are many different ways of funding an expert. The government has the option of just cutting a contract the day the judge issues a ruling and dealing with SAMs later, figuring that logistical piece out. They can commit themselves to pay Ms. Wong a certain amount of money in an enforceable contract without having her go through the rigmarole of this administrative bureaucratic system that they want her to go through. They could just cut her a check. I've employed expert witnesses from overseas who can't enroll in SAMs. There are ways to pay them. The U.S. government has figured this out. Here, the Coast Guard and the government require Ms. Wong to go through this system. Because they've required this, right now I think Ms. Wong has just received a draft contract as of today. There are some terms in there that she wants clarification on. So the contracting officer has to fix those terms, and then she will sign that contract. And maybe she'll have a signed contract by the end of the day, or by the end of tomorrow, if the contracting office fixes those specific terms.
What's the terms that are at issue?
There's some limitation on the period of time in which she can work. There's some clauses that she just didn't understand in the contract that she sought clarification on. these contracts. This one certainly didn't offer to reimburse her specifically for some of the work she's now already done by receiving and mailing these items of evidence that we've discussed in these 802s and now on the record this morning. So, either way, right now, and this is just the way the Coast Guard apparently does business, I think we're at about 59 days since the court's order. If my math is correct, which maybe it isn't, but that would still be the most expeditious time between court approval and contracting in this case. I think our record right now is 120 days to get Dr. Brock contracted after the court ordered her to be funded back in February of 2020. So the defense isn't to blame for these delays here, and the reason I bring it up is because that seems to be the crux of the government's motion. Not our fault. You should have done better, defense. You should have ran faster. You should have ran harder. Nothing we can do about this. And we offer this in closure to show you we've been running hard. We've been running fast. None of that is applicable to the remedy that's available to us. Because right now we have an expert that this court has deemed as necessary for a fair trial, and she is, that hasn't had an opportunity to begin work. And she's supposed to be funded for 35 hours that she now cannot complete before trial starts on Monday.
And why not?
It's evidenced in this letter, Your Honor.
Okay, so if you can just tell me, I'll go back to it. Why can't she do 35 hours of work, working 8 hours a day?
Well, especially before, Your Honor, she has other cases as well. I know the government's...
Before this one?
Well, this isn't her only source of income. She's a civilian. She has a practice. She does many cases. And she's still, as of today, not funded. So, I mean...
let's have a conversation about that.
Sure.
I'm curious to know if that should be a factor in the court's decision about abatement. If 35 hours are available and she decides not to use them, does that then require an abatement? You see what I'm saying? So that would be a decision that Ms. Wong would have to make.
I think I understand your question, Your Honor. I mean, number one, the funding delay caused this conundrum. Right? I mean, it sounds to me like the court was almost asking Ms. Wong, if we're going along this train of thought, the hypothetical is that the court is asking Ms. Wong in December 2016, put all your eggs in the U.S. Coast Guard, we're going to give you 35 hours of funding basket, and forego all of her work you may have in the pipe at the expense of your own income, because this is your priority. And she hasn't been funded.
So let me tell you how I'm framing this in my mind. You've asked me for a remedy. The remedy is abatement.
Yes.
And in order to determine whether the government refused to fund, that's what the RCM in the case law requires. But then...
It's not refused, Your Honor. It's failed to fund.
Yep. Failed to fund. Correct. They funded her. Right? So now they have funded her, right? And now we have a week before trial in which there, in my viewpoint, there is 35 hours to do. She knew she would be involved in trial that has been scheduled at this point. She has the time. It's just like you have other cases, I'm sure, and you have probably the sole focus of your workload right now is this trial and preparations for this trial. How is that different from Ms. Wong?
She doesn't have the time. She's not a Coast Guard petty officer. She can't be ordered to spend the next week just doing 35 hours of work for the case of USB Commander Ely. When the court ordered 35 hours of funding for her back in November, she had time from November until trial to work those 35 hours in and amongst her other obligations as a citizen of the United States, as a private citizen, and amongst her other obligations to other clients that she has. There was never any suggestion that she can do 35 hours in 1 week.
is to work on this case non-stop for 1 week. That is an unrealistic expectation to put on any prospective expert witness. That's why we raised this motion to abate. We can't.
Counsel, you've been involved in litigation, right, for several years, and you've seen funded experts have no problem sitting in a courtroom for a week or 2 weeks, and they're not working on other cases. So help me understand why Ms. Wong can't do this work from now until the start of the trial.
Well, let me just start with it. Apparently, she's still not funded because the contract isn't signed.
Okay, so I'm going to assume that she is funded starting tomorrow. Okay, for a hypothetical discussion.
So I'm just going to read from her letter then. It is, I can't speak for her, she can speak for herself. Due to my ongoing obligations in other cases, including 2 upcoming case report deadlines and 1 upcoming trial, which was continued as a consequence of COVID-19, I cannot complete my substantive work in the U.S. v. Ely case any sooner than the end of March 2021. That's because the government's failed to fund her for the last 59 days. When we first contacted her, she had the time.
So let's walk down that road. So what has the government failed to do? Just get the money into her account?
Yes, sir. Exactly. The government has failed to authorize her work, right? And we're talking big government here. We're talking about this process that the Coast Guard has for allowing us to work with expert consultants. And that is, apparently that process is, you will have a written contract signed by both the U.S. government, a contracting officer working for the U.S. Coast Guard, and the expert consultant before you're allowed to start that work. Anything you do before that is at your own risk, defense counsel, and we can't take that risk. I can't obligate U.S. government funds. I'm not authorized to do so. That would break the law. So it's just, that's the playing field. That's the playing field that the U.S. Coast Guard has created for us. And so the failure is to finish that process, which apparently takes a heck of a long time. There were certainly alternatives to that process if people think outside the box or do it in other forms or fashions. Again, there's no reason a contracting officer can't draft a contract for somebody that isn't registered in SAM, so that didn't happen in this case.
So I'm sure the government's going to talk to me about some issue with private residences and failure to put a residence on that delayed this process. Can you speak to that?
Again, all in this letter and all in these 30 enclosures are on it. I mean, number one of the government's contentions, I think, in the response was, we had no idea this was an issue. We got an email in here in which Commander Tully is copied saying, hey, government, this is an issue.
Counsel, do you not know what the fact is, or you just... I'm just asking you for what is the fact? I understand it's in here, but can you direct me to it, or can you at least give me a preview?
It's across all 30 enclosures, Your Honor. Here's the bottom line fact, is that Ms. Wong is authorized by the U.S. government to have what they call a restricted account because there have been threats to her personal safety as a result of her involvement in other cases. The defense has been clear with the government that she is not going to disclose her physical address to anybody. Within these enclosures, you have...
She gave it to him for the building process.
To anybody on the trial team. Right? The only person she could disclose her physical address to was this vetting process they had in Duns, whereby they created this restricted account for her. So back in December, shortly after the court's order saying, hey, you're awarded this funding, Ms. Wong did in fact go to this specific agent in Duns and said, hey, I have this issue. How do I make sure that my information isn't accessible to the general public? They walked her through this restricted account process, and she provided her address to this vetting agent to create that restricted account. So her address was provided to the appropriate people at the appropriate time. What the government seems to be sort of hanging their hat on is, well, there's, a regular prosecutor getting a regular SAMS account. Why don't you just give her a physical address and create a regular SAMS account to send that information everywhere? There was a solution they proffered to the government in one of these emails that wasn't tenable and ran contrary to the specific direction that Ms. Wong received from Duns and received from Cage when it came to restricting her address.
So, one thing I need clarified, right? There was a lot of misunderstanding about the timelines. The convening authority initially denied your request. Then I made a ruling about the admissibility of her testimony. After that, you went back to the convening authority, and he granted 10 hours, which you came then back asking for the 25. What is the date of the 10 hours? 6 November, correct?
Yes, sir.
Okay. And at which time, although she probably jumped the gun a little bit, YM1 Klebeck had reached out to you in advance for this SAMS process.
That was in October. She said, like, here's the general way you can establish a SAMS and DUNS account.
Okay.
All right? It doesn't matter when she did that. What authority do we have to direct a private citizen to go ahead and register in DUNS and SAMS before we have funding from the government? Right at that point in time, when YM1 Klebeck sent that email, that first email in October, which was strange for us to receive because we just received a response from the convening authority saying, hey, your request for this expert assistance, that's denied. And we get this email that says, well, this is how you establish a DUNS and SAMS account. So we email her back and say, we thought that the convening authority wasn't giving us this expert. Do you have different information?
Yep.
To which she quickly responded, oh, sorry, no, I jumped the gun. All right.
Yep.
Don't worry about it.
I'm just trying to. So you were first notified that there was an expert on 6. There was 10 hours that was approved on 6 November.
Correct.
When did Ms. Wong start the process for Dun & Bradstreet?
Yeah. It was like around 4 December. I can explain all this if you don't think this handling text.
Do you want me to tell the handle these specific facts, Your Honor? Because she was involved in the actual meat and potatoes of talking to Ms. Wong and getting this.
Sure. Yep, she can.
Just briefly, Your Honor. After we got the approval, after close of business on 6 November, after filing motions, we have been spending that entire week prior to 6 November asking trial counsel, please give us an update on the most recent second request for funding from the convening authority. As of the filing time for motions on 6 November, we had no response. So when we filed to move to compel Ms. Wong's 35 hours of funding, we did not know that the convening authority was going to authorize any funding for her.
Okay, sorry. I need you to so you got notice that you had 10 hours.
No, sir, I'm not there yet. Prior to 6 November.
Okay.
The 6 November was a motions filing deadline in this case.
Yep.
We filed a motion moving to compel funding for Ms. Wong because we had not heard from the convening authority.
Okay. Yep.
After close of business, we got an email from trial counsel, which we saw the following Monday, so around November 9th.
Sure.
By then, we're filing responses and we're dealing with obligations in other cases. I preliminarily let Ms. Wong know that it looks like we may be getting 10 hours of funding, but we want to wait until we have you take any action until we find out if we're going to get the full funding. If we don't get the full funding, we have to make a strategic decision about whether we're going to use you at all, in which case we don't need to direct her to begin the funding process.
So okay.
So
that was a strategic decision by you at that point not to start just the contracting logistics.
It was not a strategic decision, Your Honor. I let her know that we had 10 hours.
Yep.
I let her know that we're not sure what this means for the rest of the funding, and I gave her preliminary instructions, I think, over the phone about how she would register with getting this government account. She said, okay, that sounds good. She was tending to other cases. She was in trial somewhere else anyway, so she couldn't do it at the moment. This isn't something, nor has there ever been an expectation, that the moment you get approval for an expert, they have to drop their other obligations and go create a SAMS or DUNS account. So having knowledge that we had 10 hours and having a brief conversation with her about how she would get registered, we then proceeded with the motions hearing on the 18th. So within a week, we're already in this court, and we're anticipating a favorable ruling for the remainder of her funding. So right now, we're grappling over 10 days where we're already putting in motion Ms. Wong's duties to get registered in DUNS and SAM, but she just hasn't substantively taken those steps yet because she's still tending to her other duties and obligations in other cases. So by the time she gets to registering in SAMS, I think it was within days of your actual ruling, so by 24 November, It's not
Duns,
like...
right? Sam's comes after Duns?
Yes, sir.
Okay, yep.
So by the time, I think we're at 23 November, when you released the ruling saying full 35 hours, we then double tapped Ms. Wong and said, okay, we need to get you registered immediately because we have all, the full funding at this point, if you haven't already. And then I went ahead and documented in writing that these are the steps to get registered if you haven't already, and if you have any questions, let me know. Within a week of that, she alerted us to the concern with her DUNS registration process that she was being required to disclose her physical address, which she was immediately willing to do, and which we've evidenced that she did, but she did it through the appropriate avenues, and that would have been the restricted process avenue. So Ms. Wong is not the first, nor is she the last, civilian contractor who has concerns with safety or having her private home address published, because that's what DUNS does. When you provide your physical home address, they publish it in this government database, which is a security threat to her. So this was never about Ms. Wong resisting. This was never about the defense being dilatory in our actions. This was never about us resisting. This is about what's a reasonable response to get registered. And within a week of receiving any indication that there would be funding, we were already taking steps with Ms. Wong to get registered in DUNS. And then we understand the SAMS process followed. And then SAMS had a different registration process for their for their restricted process. So that's where it all, between the 6th of November and the 24th of November, we were already in motion with the SAMS and DUNS systems. We just didn't realize the discrepancy with the restricted account registration process until Ms. Wong brought that to our attention, which we immediately brought to the government's attention and proposed a resolution when we brought it to their attention. And this is all documented in the 10 December email, in the 15 December 802, the 16 December email, and then subsequent emails with trial counsel, because in that 15 December 802, you directed us to work with trial counsel, so we did that every step of the way. And so from there on out, we kept trial counsel apprised of every one of our developments, and we invited their assistance every step of the way. So the idea that we've ever precluded the government from speaking to Ms. Wong is inaccurate. We've just asked that we be included at the very least, and we've never told them not to speak to our experts regarding these logistical or funding issues.
Let me ask a different question then. You can sit down if you want, counsel. You can argue from your seat, is what I'm saying.
Yes, sir, I'm fine. Thank you.
Okay. What finally got the logjam corrected?
Sorry. Our continuing efforts with the assigned customer service assistants, first at DUNS, then with SAM.gov, then with the Defense Logistics Agency, and within that, the Federal Defense Service Desk. So, and that's what these 30 enclosures are. Pages of help tickets, pages of documented emails, pages of confirmation that you have submitted your physical address for verification and it's been approved with DUNS. Specific instructions from DUNS about how to register in SAM.gov. Then Ms. Wong's attempt to register with SAM.gov. Then the response she got back from SAM.gov. So these 30 enclosures evidence every single step exhaustively, and the letter that accompanies these enclosures, this 5-page letter, discusses Ms. Wong's steps from 24 November all the way through 7 January on a virtual daily basis. So she could not have been doing more, she could not have been working harder, and Ms. Wong was doing it all understanding that she was unfunded every step of the way, and meanwhile, instead of working with us, the government continued to provide erroneous updates to the court, which we're willing to understand that they were perhaps trying to get accurate information, but we had been telling them for weeks that you have to have an assigned agent, you have to reference this case number, you have to ask for this person to get accurate information about Ms. Wong's account status. So we were really not having productive conversations with one another. But it's all evidenced in here, including emails with Chief Warrant Officer Fernando, as was ordered by the court. So, and then also mentioned in the December 15th 802, the court mentioned that you better not hear that Ms. Wong is on vacation or that the Secret Service agent is on vacation. We communicated all of this to Ms. Wong, so she took every step in this case with urgency and, quite frankly, probably fear of being perceived as less than diligent by this court. And then she followed court orders to receive evidence and went through her chain of custody procedures and return evidence. And she's documented every step of the way. So right now she's out almost 45 hours of unfunded, expedited work just trying to get an account with the Coast Guard to receive a contract.
45 hours, counsel?
Yes, sir, and it's documented.